Hi, I'm Natalia Angelini.
And I'm Nick Esterbauer.
Welcome to Holland Estates. You're listening to episode number 559. So today we're going to be discussing a recent decision. It comes out of the Ottawa Superior Court of Justice, and it really caught our interest. There's some recent decisions lately that are really creating quite a bit of debate within our bar, and this is one of them that has created some discussion, at least internally here, wouldn't you say, Nick?
Absolutely. So it's a scenario we see all the time. The applicant for as guardian of property is the mother of a young man who is incapable of managing his own property. She's been helping him out until he reached age 18 and for some time after that. And then what we saw happen after this application was brought was maybe a little bit different from what we see on a lot of our files.
Right, and it was, I guess, fairly run-of-the-mill in terms of this is mother of an incapable adult. I think he's 23 years old, so she's been already helping him informally for several years into his adulthood. It's an unopposed application, so the public guardian and trustee was served, chose not to take a position. The son himself was even in attendance at court, I think, at the hearing, or at least one of the hearings, and he gave no indication of having any opposition to the application. And yet the judge refused to grant all of the relief. So the judge did grant some orders, for instance, the finding of incapacity.
That's right. And
the judge certainly had no doubts as to the mom's being properly qualified to act as her son's guardian. They undeniably had a close and loving relationship, and she's devoted her life to his care.
And it's funny, I found it funny anyway, that there's actually a reference to her being an appropriate person to act, and the likelihood that eventually down the road, after she's fixed the issues that the judge referred to, she will be appointed as guardian of property.
Right. And so the sticking point really all comes down to the management plan. And this is where the judge, I think understandably felt that some of the evidence, because there was evidence as to the structure of how he could be receiving money for the duration of his lifetime, because he is the recipient of a settlement in respect of a personal injury matter. I think that's how he became incapable in the first place when he was much younger. And so he was going to be the recipient of a significant settlement sum, I think about $1.4 million. And so there was some evidence that the mother had obtained from the Bank of Montreal, and with whom the monies were to be invested, and as well from, I think it was Henderson Structured Settlements.
That's right.
But there wasn't direct evidence. There were no affidavits from either of those two entities. And so that's what Her Honor was not satisfied with. And I get that. I get you want to have the best evidence before the court, and perhaps she just wasn't comfortable without that. But when you actually look at we know what we know gathered from the actual decision, but in reading the decision, you get the clear impression that the mom put quite a bit of evidence in the management plan, or information in the management plan, that I would think would probably satisfy most judges hearing unopposed guardianship applications in these circumstances. So the decision is a bit of a surprise that Her Honor adjourned the hearing so that direct evidence could be obtained from those two entities, and also further evidence could be obtained in terms of, I guess, one issue which we found a bit unusual, which is not just are these funds sufficient to care for him while me as mother am acting as guardian, but also when I'm no longer guardian. That was a real twist here.
So that was a bit unusual in my mind anyway, that this mother had agreed to act as guardian of property without receiving any compensation. And one of the issues that the judge had with her management plan was the fact that she doesn't contemplate the payment of compensation to a successor guardian down the road, which is a bit unusual.
Right, because the reality is let's say, and the judge quite correctly identified, it's impossible to know how long mom is going to be able to care for her son. So, but that said, if and when that happens, You're going to have a new guardianship application with a new proposed management plan, and all of those questions should be satisfied by way of that process.
Right.
So it is unusual for us to see that the judge really forecasting to the future beyond the currently contemplated guardianship.
Another issue that the judge raised was even before the replacement of the mother as guardian of property by a new guardian, the judge wanted the plan to contemplate what will happen as the incapable's needs increase, where
That's
she's
right.
not able to provide so much care, maybe in terms of physical caregiving,
Right.
and when she needs to hire assistance in that regard,
Right.
while she may continue acting.
Right. Yeah, so it definitely sets the bar higher than I think we see often. So it's, I guess sort of a message to practitioners to take a very thorough approach when preparing your management plans. I mean, unless this decision would be appealed or is going to be appealed, and I don't know that it is. I'm trying to remember the date. Oh, it is. No, it is quite recent. So we'll
That's
time.
right.
The jury's still out on that, but it is certainly a reminder to take a very thorough approach, and that does add to the cost, because it's no small feat to put together a proper management plan. So, if now that the signal's being sent that, hey, you've got to make sure you've got not just your evidence, but direct evidence from other entities or financial institutions. So that's all gonna add.
And that applies also whether the guardianship application is opposed or not, because in this
Right.
case we see it unopposed. The public guardian and trustee, I don't think, was taking any position. So it was an unopposed guardianship application, and I found it sort of interesting how the judge used the rules of civil procedure to look at this matter, and because of the amount of money involved, decided that this was a contentious
Right.
issue to deal with.
Right.
Not
She made that
uncontentious.
specific finding that because of the sum of the settlement monies, it was contentious.
Which makes me think that anytime we're dealing with large sums
Right.
of money, which we often are when guardianship applications are being contemplated, we need to be very careful with those plans, make sure that they're forward-looking
Right.
and comprehensive.
Right, and even the question of posting a bond was not resolved, because Mum, I think routinely sought that the cost of the bond be paid out of the son's assets, and the judge didn't seem to have any difficulty doing that, except that there was no express authority provided for it, and so wasn't willing to make that order on that date. It gives us all pause to really get our I's dotted and our T's crossed when we're bringing these applications, which I think any counsel who's trying to take a careful approach would do that, but this case most definitely specifically delineates areas where we need to take a careful review of. So it's a bit of a surprise, candidly. I think we're a little bit surprised, and we'll have to be advising clients in terms of the cost implications of some of the steps that you have to take that maybe people wouldn't necessarily have done beforehand.
And we may need to consider in the future whether or not we require direct evidence from
Right.
from individuals whose reports we're relying upon.
Right. So I guess it's yet to be seen. This may be viewed as an outlier decision. It's too early to say, or it could be picked up and carried forward in other cases. So it'll be interesting to see how it's treated going forward.
For sure.
Still very early days. So unless you have any other comments or thoughts,
Nope.
we will have a link to the case on our website. So it is Connolly and PGT. And that concludes our podcast. Until next time, I'm Natalia Angelini.
And I'm Nick Esterbauer.
Should you have any questions, please email us at webmaster@hullandhull.com or leave a comment on our blog.